If I can ask everybody to come in and lower your voices, we're going to get started. Okay. So I call this meeting to order. This is the meeting of the Select Board on January 19th, 2024, 5 p.m. to consider whether any disciplinary action should be taken against Sergeant Timothy Brennan in connection with alleged violations of departmental policies. At Sergeant Brennan's request, this personnel matter is being considered in open session. I advise all people present that this is not a public hearing, and I hope all will be present will be respectful and not disrupt the proceedings. First, I want to just thank you all for coming. I know this isn't easy for anyone, and I know for some, emotions are running very high. This is challenging for me and the Select Board members as well. I wore my high school class ring tonight, as I do at times when I'm facing difficult circumstances. It's a bit of a touchstone for me. I was lucky enough to attend Worcester Academy, and the school motto resonates with me always. The motto is achieve the honorable. That's what we are hoping to do tonight. All of us are hoping to do that tonight. In a tough situation, we want to do what is right. We want to be right for the survivor and for all survivors. We want to be right for you, the public, and for everyone in the community. And we want to be right for the Hopkinton Police Department. We want to be right for the chief and for Sergeant Brennan, both who have dedicated decades of their lives to service in uniform in Hopkinton. This has not been easy, and the resolution may not be easy either, but there is a way forward. I know that. And I think that we can find the accountability and the restoration we're looking for. There's a concept in justice reform work that recognizes and accounts for harm while working collaboratively to restore and repair that harm. It's called restorative justice. That's the work I hope we do together tonight. So I want to say for the record that I have known Tim Brennan for about 20 years, first meeting him when I was first on the Select Board 20 years ago. And our families have been close personal friends for about 15 years. Also, for the public's benefit, I want to let you know that the Select Board received the totality of the documents that we had to review on Saturday, January 13th, before what was scheduled on the 16th. We'll hear from the chief, we'll hear from the attorneys, we'll hear from Sergeant Brennan, and the Select Board will have an opportunity to ask questions and then deliberate. The public will not be allowed to speak, and we ask that you refrain from disrupting the discussion in any way. No clapping, no comments, etc. I know we're all here working to get to the same place, a resolution that helps us heal and move forward. Okay, at this time, I call upon Labor Counsel Nick Anastopoulos to summarize how we got to this point and the department's position. At the conclusion, Sergeant Brennan and Attorney Fogarty will have the same opportunity.
Good evening, Madam Chair, members of the board, members of the Hopkinton community. My name is Nicholas Anastasopoulos, and I've had the pleasure for approximately a dozen years to represent this community in its labor matters. As a preliminary matter, and as a matter of housekeeping, and I reviewed this with Attorney Fogarty, at the instruction of the board, the parties were asked in advance of today's hearing to provide any exhibits and documentation. The town did that, and on behalf of the union and on behalf of Sergeant Brennan, Attorney Fogarty did the same. What I provided you is sort of the list of the exhibits for purposes of the record. There are 11 of them, and if necessary during the testimony or during either party's presentation, if there's a need to reference them. I did not include the union's exhibits because I didn't want to be presumptuous that we would be running from number 11, 12, 13, 14, or whatever the number was, or if the union wanted to mark them separately. But there were, I believe, 3 documents that were submitted to the town manager's office and the town manager before the close of business on Friday, and I think early Saturday or late Friday evening provided all of those documents. So I think the board has both the town submissions for the record 1 through 11 and the documents submitted by the union through the town manager. So are we Is that accurate? Everybody's had an opportunity to review it, and that was in advance of what we thought was going to be the Tuesday hearing that was rescheduled for today.
Yes. Can I excuse you for 1 second? I'm
Sure.
sorry. I was supposed to make an announcement that we have resources in the room for anybody who might find the subject matter of the discussion tonight difficult, and I forgot to do that. So this hearing has stirred up a lot of emotions, and outcomes can be hard for individuals. So Hopkinton Youth and Family Services has provided some contact information and some services, and the flyers are available in the room. If you don't find them and you need them, we will provide them to you. I apologize for interrupting you.
No. It's your hearing. So yeah, I think it's interesting that you asked, how did we get here? And so in my practice as a former prosecutor and then labor counsel for the city of Boston and now working for the firm that I've been with for over 20 years, I have to say that I very rarely vividly remember a call coming in and the topic of that call. And this was sort of that call and that exception to the normal rule. It was August 24th of 2022, and I remember driving to a client meeting in Boston, and it was well after 5 o'clock, and the number that shows up is Norman Kamalos. And any of you that have worked with Norman in this community know that a call after 5 o'clock is really nothing to be alarmed by from Norman, except that on this call, Chief Bennett and then Town Council Raymond Yaris was on it. And what I heard next literally stopped me in my tracks and had me pull my vehicle over. It's not every day that you hear the second highest member of a law enforcement agency, in this case our deputy chief, someone that I had worked with on a variety of different matters, whether labor-related matters, matters in the community, discipline of other officers, whatever the case may be, was someone that I knew and worked with, and to hear what the allegations were, the indecent A and B, and the statutory rape of one of our members of our community, needless to say, was staggering. All of us on that call immediately understood that the allegations were of a nature that would be difficult to navigate, and in what ways. Obviously, the topic was an explosive one and a problematic one. There was an absolute need to protect the victim, simultaneously the absolute understanding.
Could we refer to her as the survivor, please?
Sure.
For me?
The survivor, and also the need to assist and do no harm, and really emphasizing the do no harm to the prosecution of this matter, right? So everybody understood that, and what we also understood, and throughout this process, we have been very clear and very deliberate. What we also understood was balancing the due process of any of our employees in terms of their property right, and what that is their right to this job as tenured members of that police department, as you indicated, the long years of service of both of the individuals involved here. Balancing those due process rights and their employment rights and the difficulty around privacy rights, union obligations, union notices, etc. Trying to do all of that and understanding what happened here with everyone that was involved either directly or indirectly. So at the end of that, probably a half hour, 45-minute conversation, I think I said, I think I want to quit. And so Norman did not accept my, request to quit. And so we proceeded. Like you, I acknowledge that this is a difficult topic for the town. I acknowledge that this has been a draining, intense exercise for the board. And I truly wish, as you indicated, that your work tonight was going to be easy. I don't think it will be. But I'm glad to hear that you're prepared, as we all are, to do the work. Paramount in all of the work that we were doing in trying to deal with this issue was making sure that our community was safe, and that simultaneously we were holding members of the department accountable, both internally in terms of our internal affairs processes when it was appropriate to do it, and externally supporting the district attorney's office. I think in government work, there's forks in the road where you have to make decisions, and as board members, department heads, forward-facing members of various departments, there are easy decisions that you have to make, and there are difficult decisions. There's easy work and there's hard work. And I think that's what this case is about. It's about making those decisions and making the hard decision when required to do so. So what is this hearing? I think there's been a lot of question, and It's obvious that it's been out there in the news and then blogs and then, other forum. This is a Loudermill hearing. The purpose of this hearing and what we did was to give Sergeant Brennan an opportunity to understand the charges and what the proposed discipline would be as a result of those charges and finding. This is not a full hearing. Because Sergeant Brennan is a member of the union, through his union contract, there are various steps to the grievance process and then ultimately an arbitration. The arbitration would be, the arbitrator at the arbitration would be selected mutually by the parties, would be an independent third party, and ultimately, and I guess what I would say is, there may be a determination here, he would sort of have appellate rights to that determination in front of that neutral arbitrator. Unless the arbitrator did something that was repugnant to public policy or patently illegal, that determination would stand and it would be binding on all of us, and we would abide by it. That is the process that has been negotiated. As you indicated, Sergeant Brennan is completely within his rights to have this matter be a public hearing. I believe in all the years that I've been labor counsel, there's only been one other public hearing. We regularly have these hearings within the department, other departments in town, and typically they are held in executive session. If nothing else, this process has shown that as an individual, Mr. Brennan, if nothing else, can turn out a vote and turn out a room. But we're not here to talk about, as you indicated, sort of the relationships that many of the people in this room, folks on the board, I've had opportunity to talk to Tim on the side as an individual. That's not what we're talking about here. What we are talking about here is the sworn officer and the duties and obligations that he has to the department and to this community, and were his actions appropriate surrounding the situation that we're dealing with. You know, I've had the opportunity over the years to have interactions with different town managers, department heads, employees, union leaders, attorneys. And it occurs to me, sort of there's, in public service, there's, the easy work and then the hard work. He's deceased now, and I don't know if he's a relative, the commissioner over in Marlborough and the DPW, Ron Lafreniere, once told me, I don't need half of my guys, but I keep them on because when there's power down, an electrical storm, snow, I need them to show up those days and do the good work. Anybody can show up and mow the lawn and chalk the ball field and do the easy work. We need them for the hard work. I've spoken to a union leader at a fire, with a fire union. We were talking about sort of the hours that they work and the things that they have to do. And he said to me, you don't pay us to do what we do every day, but you pay us for what we might have to do someday, right? So, we have programs that we put car seats in expecting families. That's great. It's important work. It's good work. But what we want our firefighters to do is when that baby's in a burning building, for that firefighter to go into the building. That's the important work. And I think what this case is about is what's the important work in a police department. And so what we're saying here, and what the chief is going to share, is that while it's important to do community policing, of course it is. While it's important to be the school resource officer, of course it is. In ways, that's the easy work. The hard work is policing when there's an indecent A and B and a rape allegation. The harder work is policing an indecent A and B and a rape allegation when it's a minor. But to be sure, the hardest work, and when we need our officers to step up the most, is when it's a policing work related to an A and B rape of a minor and the alleged perpetrator is one of our own.
So, Chief, what is your recommendation?
Madam Chair, thank you. Just like to say that I want to thank the town for gathering. I'd like to thank the town for gathering resources. I personally have spoken with Director Alcott and the superintendent of the school district, and they guarantee that they're standing ready for anyone that become harmed. I appreciate the town for providing that. and I won't read my paragraph. I apologize in advance for what I'm about to say for those who will be harmed. I can't imagine that, and I will try to use the word survivor, that a survivor hearing these conversations and this topic is not going to trigger or harm them. I can only imagine that it wouldn't. As the community, as you and the community are aware, we currently have a former deputy police chief of the Hopkinton Police Department facing serious felony allegations involving a child that are alleged to have occurred while he served as the Hopkinton Police Department school resource officer. Specifically, the Hopkinton officer stands criminally accused of 3 counts of child rape. These heinous and vile charges will be adjudicated by the criminal justice system. That officer has since left the department. What we're here to discuss tonight are matters that are not in dispute. By his own admission, in 2017, Sergeant Timothy Brennan of the Hopkinton Police Department learned from the alleged survivor that she was actually assaulted by the deputy when she was 14 years old. The victim stated the deputy had placed her into his police car, drove her to a side street near the police station at a church, and told her to wait. The deputy then returned and picked her up in his personal vehicle. The survivor, in 2017, further told Sergeant Brennan the officer then kissed and fondled her breasts. She was a child at the time of the horrible assault. With this knowledge that he had since 2017, Sergeant Brennan did and said nothing. As a result of Sergeant Brennan's inaction and silence, a Hopkinton police officer with an unreported allegation of sexual assault continued to go uninvestigated, continued to hold positions of power, and continued to advance within the organization. The deputy in his role became a very public-facing image of the department. It is also very concerning that given the nature of the allegation, the deputy continued to coach girls soccer after 2017, when Sergeant Brennan, a member of the Hopkinton Police Department, became aware of the sexual assault. Sergeant Brennan's inaction and silence eliminated the opportunity for the Hopkinton Police Department to investigate, or for any outside agency to investigate the allegations made against the deputy. To be clear, Sergeant Brennan does not have the rank, authority, or discretion to make such a decision to stay silent about such a serious allegation when made against a member of the Hopkinton Police Department. Sergeant Brennan has a duty, an obligation to report such allegation. He admits this. Especially troubling is the fact that the allegation was made against a sworn member of the Hopkinton Police Department. Compounding this failure to report or act is the fact that Sergeant Brennan has specialized training on sexual assault investigation. Sergeant Brennan has provided training records that specifically address the fact that investigators will face difficult situations, including accusations against prominent people, including police officers. As a matter of historical reference, on August 24th of 2022, as stated, I received a phone call from a member of the Massachusetts State Police assigned to the District Attorney Marion Ryan's office. And I was told that the detectives were en route on the way to meet with Sergeant Brennan to discuss allegations against the deputy related to a potential sexual assault of a child. The only way our community found out about an allegation against a member of our department was from a state trooper. I was instructed at the time that in order to protect the integrity of the investigation, that I not discuss the nature of the allegation with anyone, including the deputy. I confirmed that investigators were aware that Deputy Porter was currently a coach in a neighboring community where he coached girls' youth soccer. While the criminal investigation was conducted by troopers assigned to the District Attorney's Office, the Hopkinton Police Department stood ready to assist the investigation in any way as requested. I personally provided documents, emails, research, and physical items as requested by the District Attorney's Office. I kept the Police Officers Standards and Training Commission apprised of all investigations relative to this matter. My responsibility was to ensure that in no way did I or any member of the Hopkinton Police Department assigned by me interfere with or wrongfully inject themselves into the investigation. The criminal investigation was in the full jurisdiction and control of the District Attorney's Office. Sergeant Brennan first told me in January 2023 that he knew the deputy assaulted a child. I was under the impression at that time Sergeant Brennan had been silent for only weeks, not years. Based on statements that Sergeant Brennan made, and when it was clear that an internal investigation would not interfere with when an internal investigation would not interfere with the criminal investigation, an internal investigation was launched. Consistent with best practices when investigating such a serious matter, the town contracted an outside investigative firm to conduct the investigation. At the conclusion of the investigation, Sergeant Brennan was found to have violated a series of rules, regulations, policies, and procedures. Police officers are given tremendous power. And with that, with power comes immense responsibility to the community they serve, protect, and police. To ensure proper behavior by our police officers, they are guided and governed from and by many sources. This governance and guidance includes our oath of office, the United States Constitution, United States law, the Massachusetts Constitution, Massachusetts general law, judicial case law, and the Massachusetts Police Officers Standards and Training Commission. Here in Hopkinton, Hopkinton police officers are guided and governed by the town charter, town bylaws, the town's vision and mission statements, and the town's pledge. Within the Hopkinton Police Department, officers are expected to follow rules and regulations, policies and procedures, and department directives. As a nation, and hopefully in Hopkinton, police officers are held to a higher standard than the general public, and rightfully so. Officers are also expected to comport themselves in an honorable manner, both on and off duty. I'd like to state emphatically that I have no tolerance for those who abuse or victimize others, especially those who victimize members of vulnerable populations. As we discuss this matter tonight, unfortunately, the survivor at the time of the alleged assault was a child, a student, and a member of an extremely vulnerable population. What we are talking about here is not in dispute. Sergeant Brennan's inaction and knowledge and belief in what is alleged by the survivor are not in dispute. Sergeant Brennan has at no time stated that he found the alleged survivor's statement to not be credible. Many victims are hesitant to participate in prosecution. Victims of sexual assault and domestic violence are those who are among the most commonly hesitant victims or survivors. When a survivor is reluctant, police officers work to serve victims and stand ready should they decide to come forward with prosecution. Professional counselors are made available and resources are provided. This happens daily across law enforcement agencies. In fact, locally here in Hopkinton, we have active similar cases currently at the department that we are handling. Reports are generated, statements are taken, and evidence is collected and secured. This is all done to support the survivor in the event that they choose to move forward with a prosecution. I spoke about the governing documents and entities that govern and oversee police officers in the Commonwealth. It's my belief that a police officer's uniform is the first impression we make when we interact with the public. Our uniforms are adorned with many symbols. These symbols have significant meaning. These symbols tell the public who we are and what we stand for. The symbols show our power, but also show the standards we will be held to, as I described earlier. The most important symbol that adorns our uniform is our name tag. Within the Hopkinton Police Department, it is historically demonstrated that we hold each other accountable when officers choose this career. They choose to don this uniform, and they must accept the responsibility and duty that comes with it. I will not tolerate officers concealing, covering up, staying silent, or standing by while officers commit unlawful acts of violence, sexual assault, racial bias, excessive force, or any other heinous acts. Silence and inaction is simply not acceptable. As a Massachusetts police chief, I am only authorized to issue discipline up to and including 5 days of unpaid suspension. Discipline beyond a 5-day suspension lies in the authority and is the responsibility of the Select Board. I was directed to provide a recommendation to the Select Board of the most appropriate punishment that I felt should be considered. Based on the undisputed fact, I am left with only one recommendation. I hereby recommend the termination of Sergeant Timothy J. Brennan of the Hopkinton Police Department, effective immediately, for the violation of following rules and regulations and policies and procedures. Number 1, professional image. Rules and Regulations 10.1. Sergeant Brennan failed to report an inappropriate relationship which amounted to conduct unbecoming an officer on Porter's part. Number 2, attention to duty. Rules and Regulations 10.0. Failed to report sexual assault, failed to report rape, failed to support a fearful victim. Internal Affairs Policy 4.01. Failed to report sexual assault, failed to report rape, failed to support a fearful victim. And General Order 2018-004, failed to report sexual assault, failed to support a fearful victim, failed to report rape, failed to report an inappropriate relationship which amounted to conduct unbecoming an officer on Porter's part. In closing, Sergeant Brennan's silence and inaction prohibited the department from investigating such allegations. Further, Sergeant Brennan failed to provide any substantive support for the alleged victim. A police department cannot serve the community if its officers are allowed to conceal, stay silent, or stand by illegal, violent, and heinous acts committed on anyone in this room, committed on anyone in our community, or committed on our children, let alone committed by one of our fellow officers. Thank you.
Thank you. So I wasn't sure if folks would have the actual paper or what's on your electronic devices. But obviously in our doing our due diligence, we did consider concerns raised by the union and counsel for Sergeant Brennan. And within your packet is a letter from an attorney who has a tremendous amount of experience in human trafficking and is now in private practice as a criminal defense attorney. And contained in that letter was a footnote and some live links. And so I don't know if folks realized or thought to click on those links and to look at them. And so in case that didn't happen, and because it's one of our exhibits, I did bring copies for the board to have. So again, because there's been a lot of discussion in and around town about our department rules, regulations, what was in place, what was known, what was unknown, I don't think there is any dispute that if the board spent the necessary time, which I know you did, because of the individual conversations we've had and keeping you up to date, in the executive session that we had, I know you're up to speed and I know you did the necessary work. But to the extent that there is any question about what the chief is saying to you and the expectation of officers, particularly trained officers in sexual assault cases, you frankly don't need to look much further than the footnote and the documentation presented by the union as part of its exhibits. The document that I put in front of you is the guidelines for law enforcement response to adult sexual assault. And it was cited to, and the fact that this was a 14-year-old only further complicates, doesn't mitigate the expectations of law enforcement officers. And note that this is a document that was created and generated and circulated and now shared as a source document for you from 2017. If you look at section 1, starting on page 8, it talks about the purpose and the guidelines and its overview. And it talks about.
Hold on one second.
Yep,
Where
sorry.
And also, we should have had this.
Well, it was in the
Sorry,
footnote.
I'm just saying. we
Okay.
should have had this.
Yeah,
This is a lot to be presented with on the fly.
right. Well, we got it on Friday. We didn't have it ahead. This isn't my exhibit. This isn't a document that we put forward the other day.
Okay, what page?
Page 8. If you look at page 8, it talks about the purposes and guidelines overview. And when looking at the letter provided by the union, it does talk about 3 core principles, and there's no doubt that a trauma-enforced response is appropriate. We don't dispute that. But what it also talks about there is there are 2 more steps: a thorough and sound investigation and interagency cooperation. That didn't happen here. As you go through this document on page 10, it specifically calls out indecent assault and battery on a child of 14. When you go to page 18 of this document, it talks about reporting challenges, all of the things that were contemplated and considered by Sergeant Brennan, but none of those reporting challenges are hurdles that aren't to be overcome or considered and addressed. Specifically states reporting challenges, as with many crimes, a successful prosecution of a sexual assault is often predicated on the victim's willingness to report the crime, to provide enough detailed information for the case to be fully investigated. With the pending criminal case, the delay, based on the information provided and the delays, has the potential to significantly harm the successful prosecution of this matter. Further, 2 paragraphs down where the bullet points are, even a relatively straightforward allegation of sexual assault, investigators may face challenges, including gender biases, anonymous reporting, recanting. At the top of the next page, in December 2015, the Department
Can I
of...
ask you to pause for 1 second?
Yep.
I have a question I'd like to record so I can ask it later.
Yep.
And wouldn't you want to have a pen that works? I got it, thank you. Okay.
Sure. At the top of the next page of 19, it talks about 8 key principles. And one of those key principles, and I think obviously the reason that we're here, if you look at number 7, specifically states, hold officers who commit sexual assault or domestic violence accountable. The next section talks about victim recantation, and at the very end, even in situations where the decision is made not to pursue a criminal complaint, and I think that's an important thing that we have here, that we have someone that approached someone that they knew was a police officer in our department, approached someone that they knew was that individual's SRO, knew that the person was a police officer and a sergeant, and kept coming to him with information. The first piece of information was on her 18th birthday. Suddenly, the defendant in this criminal matter shows up at her door to have a sexual relationship. The next time he has a conversation, or later, albeit a few years later, the same person comes to the same police officer in the same department and informs him, well, it started even sooner when I was 14, and there was kissing and fondling. And then the same person comes back to the same police officer. We want to talk about survivors. Comes back to the same police officer, not a random member of the public, not some other employee of the town, to the same police officer, and tells her it was much worse than that there was penetration. So yes, somebody may say, if you tell, I'm going to deny. Well, as the chief just told you, people frequently deny, people frequently recant, and it's considered in this document in terms of guidelines on how to deal with it. The issue that the chief has, the issue that the department has, and the reason for the recommendation and termination is that Sergeant Brennan exercised none of his training, didn't do anything in these guidelines to deal with the issues around recanting, providing support to this person. On the next page, in the second paragraph, it says, stated above, if the only indication that the victim may have not been truthful in their story has been recanted, the investigator should automatically not conclude that the initial report was false. Recantation does not mean that the allegations made in the initial disclosure never occurred. There may be numerous reasons why the victim, survivor, recants their original statements. And then on page 55, it talks about high-profile investigations. And I think the chief talked about it under section 13. In the middle of that high-profile investigations, your job is to investigate the report and facts as you find them. Your ability to be impartial and ensure the victim is treated fairly and with dignity is paramount. If the investigation creates a real or perceived conflict, the best practice may be to have that case handled by an independent and detached party. Consult your department policy, your supervisor, and the district attorney's office. For years, that did not happen. Additionally, there's been discussion about how the department handled this matter and what the department should or shouldn't have done. From my perspective, and take it for what it's worth, I'm of the opinion that it was handled in textbook manner. Unlike Sergeant Brennan, unfortunately, the moment that the chief found out about this investigation, he immediately informed the town manager and town council. Almost immediately, taking into account the need for some coordination, immediately placed the deputy chief on administrative leave and took him out of the workforce and took him away from access. Always prioritizing the criminal prosecution, was sure to make sure we didn't rush into an internal affairs investigation that may jeopardize that. Consistent with the manual that I just referred to, he recognized the need because not knowing the scope, hired a third-party investigator. And to be clear, the investigator that was hired, Kroll, and Dan Linsky that was assigned from Kroll, his charge wasn't simply to talk to Sergeant Brennan. His charge was a much wider charge to find out who knew what and when. And in fact, the first person that he interviewed, the interview started with our chief. You know, you can't help in this matter to know that there have been postings on social media and through various news networks in the comments. And there's talk in that about vetting, and that if the department had somehow better vetted the defendant in the criminal matter, our former employee, he would have never been elevated through the ranks. I agree, and the department agrees 100%. But I think what we all must understand is that vetting requires information, and vetting requires people to come forward and to share that information. A department cannot vet its applicants on the front end. A department cannot vet its current officers for promotion if we do not know for years that another officer in that department is aware of sexual assault on a minor. The chief touched on this issue of coaching, and the chief, again, in social media, how long did the chief take to inform anyone? Chief at worst took days to inform folks and told the state police immediately, and neighboring communities, and told the state police immediately. Sergeant Brennan didn't do that. For years, Sergeant Brennan watched Deputy Porter coach youth hockey teams, soccer teams, girls teams, year after year after year. As I started to say earlier, you have a difficult job to do tonight. And I know this has been difficult for everybody here. But it's also been difficult for the officers at the station. And I'm aware as Labor Council, there's a grievance been filed over the promotional process. And while it's slightly unrelated, I think it brings up an interesting point. During the hiring process or promotional process, individual applicants or officers are presented with scenarios and fact patterns that they are pressed to respond to. I submit to you that if your fact pattern for a promotion or a hire, the fact pattern was put to an officer or an applicant that indicates that a former high school student approaches you and informs you that on her 18th birthday, she had sex with a much older adult acquaintance, suggesting grooming. Later, that same person tells you that in fact, when I was 14 years old, that person fondled me and kissed me. And then later, that same person then adds more information and says, no, when I was 14, that person actually penetrated me digitally. And then the last fact pattern that they give you is that this person is a superior officer, someone in your transcript that you refer to as your boss. And you ask that person, how do you handle that situation? I promise, well, I'd like to think that if the answer to that question was, she's not willing to come forward and he's my boss, I'd like to think that that person doesn't get hired by Hopkinton. I'd like to think that person doesn't get promoted by Hopkinton. And based on the chief's recommendation, that person shouldn't continue to be employed by the Hopkinton Police Department. Thank you.
Thank you. Okay, so I now offer the opportunity to Sergeant Brennan and Mr. Fogarty to respond.
Thank you all for meeting with us today. My name is Daniel Fogarty. I'm an attorney at Sanduli Grace. I'm here this evening representing Sergeant Timothy Brennan on behalf of the Hopkins Police Arbitration Association. Before we get into what we prepared to discuss, I just want to address an issue that seems to be coming up. First of all, as far as the exhibits from Sergeant Brennan, in compliance with the town manager's request, we provided 3 documents: a cover letter from me, a letter from Attorney Keeley, and a statement from Sergeant Brennan by the deadline last Friday. And it's our understanding that those were all shared with you. We hope you have had the opportunity to review them. We did not offer the guidelines in full that have been provided with you to hear today. And we were not told by the town that they intended to reference them outside of how they supported Attorney Keeley's conclusions. So I'm kind of hearing their presentation and understanding that they were going to talk about them for the first time with you. We'll talk about a number of the things that come up throughout. This is going to be a lengthy conversation, obviously. But I just want to pick up on something Attorney Anastasopoulos said. He referenced how the survivor came to the same officer on a number of occasions and shared information with him. I want you to think about throughout this hearing, why would someone do that? What environment did Sergeant Brennan create for her to share this information with him? A trusting environment, a compassionate environment, an environment that allowed her to build up the willingness to share more and eventually to come forward. It's not clear to me that had he acted differently, that this information would have become public in the way that it has now. And I think that that's important when we think about why Sergeant Brennan acted the way that he did. So to get back to introductions, as I said, my name's Daniel Fogarty. To my right, as you know, is Sergeant Tim Brennan. He's going to introduce himself and let you guys know a little bit more about him, though I'm sure much of it you already know.
Good evening. I want to thank the board members, Norman Kamalo, Chief Bennett, and all attendees for their time here tonight. I am truly humbled by the outpouring of support from the community and appreciate the difficult situation that is before us tonight. I have been a resident of the town of Hopkinton for 24 years. I am married and we have raised our 3 children here in Hopkinton. My professional experience includes over 36 years in law enforcement. Prior to working for Hopkinton Police, I worked for the Bentley College Police Department as a dispatcher, a patrol officer, an officer in charge, a sergeant, a shift lieutenant, and then an operations lieutenant. It was at Bentley College that I received my training in the RAD program, all including the basic, the advanced, and the kids RAD program. The RAD program approaches women's self-defense training from a survivor's point of view. I'll try to keep that up, Meryl, but it's through her quite a few times. From a survivor's point of view. Over the last 30 years, I have been a part of certifying over 1,000 women in this form of self-awareness and defense training. It is also during my time at Bentley that I became certified as a rape and sexual assault investigator. This training teaches law enforcement personnel how to talk and interview victims of sexual crimes so they are not re-victimized by the justice system. Since coming to Hopkinton, I have held the roles and ranks of special police officer, full-time police officer, school resource officer, detective, sergeant, and administrative sergeant, and have continued to teach RAD and be certified as a rape and sexual assault investigator, among other certifications. I have had 0 discipline in a 36-year career in law enforcement.
Thanks, Tim. Also here with us this evening is attorney Elizabeth Keeley, all the way to my right. She is an expert in investigating and litigating sex abuse cases with more than 15 years of experience as an assistant district attorney and in the AG's office. She's now in private practice. She's provided written testimony in support of Sergeant Brennan that was shared with the board last week, as I referenced. As we've heard from the town, the board is tasked today in deciding whether or not Sergeant Brennan should be disciplined based on the allegations put forward in the town's Loudermill notice, and whether the town should follow the chief's recommendation for discipline, issue some other level of discipline, or return Sergeant Brennan to work without any discipline. The town referenced a grievance and arbitration proceeding that is available to Sergeant Brennan after this hearing, if necessary, but I want to implore you that it is our hope that we can resolve this tonight. We think that this is the appropriate form to do it in. Taking 9 to 12 to 18 months to go through an arbitration process, to have someone from outside Hopkinton make this decision, it's not something that we want to do. We hope that we can come to a resolution that brings Sergeant Brennan back to work. The town's Loudermill notice included 5 specific allegations against Sergeant Brennan concerning his interactions with a specific individual, who we'll attempt to refer to consistently as the survivor, in an effort to respect her privacy as well as what Sergeant Brennan did or did not do with certain information that was shared with him. This evening, we plan to discuss the facts of each allegation. The chief didn't specifically touch on all 5, but I think it's important to make sure for complete record that we do address each of the allegations that were brought up. We'll also address concerns that we have with the investigatory findings and the chief's recommended discipline. But before we get to that, I think it's important for Sergeant Brennan to explain how he came to know the survivor.
Thank you, Dan. Thank you, Dan. I'd like to provide some context about how I came to know the victim and why she may have felt comfortable sharing this information with me. In July of 2005, I became the Hopkins School Resource Officer, replacing Officer John Porter, who had held that role as SRO from 1999 until 2005. It was 2005 when I met the victim in my role as SRO. In this position, I was charged with establishing trusting relationship with student and staff. I took this aspect of my position seriously and establish trusting and professional relationships with many students, staff, and administrators throughout the district. My interactions with her were professional, and I was a mentor to her as is part of the role of an SRO. I had supported and encouraged her to continue her education after high school. She stayed in occasional contact with me after she graduated. The relationship we had was always professional and supportive in nature.
As I mentioned, the town's notice identified 5 potential grounds for discipline. In addressing each allegation, I think it makes sense to proceed chronologically. First, the town alleged that Sergeant Brennan violated department policy when his family hired the survivor to babysit their children while he was assigned by the chief to work as a school resource officer. The chief did not raise this allegation, I think for good cause, because this allegation is wholly without merit. No policy or rule against hiring a high school student as a babysitter existed at the time in question. The policy relied upon by the town was not created until 2017, well after the time in question. The investigation report claims that Sergeant Brennan signed an acknowledgement that he reviewed this policy, and that's true, but he signed an acknowledgement that he reviewed that policy in June of 2017. The town does not offer any other policies related to this issue, and it is not shown, and it cannot show, that Sergeant Brennan was on notice of any rule or requirement that he notify his supervisor or ask for permission before having a local teenager babysit for his children. Even if the policy did exist, it's not clear to me that it would fit under the category of a private off-campus meeting. He wasn't acting as an SRO in his capacity and having this interaction. The meeting was not private insofar as his family and his children were present. And I think it's a fairly common occurrence. As a father of a 5-year-old, I know I'm often trying to find someone who will babysit my children, and at times it has been a high schooler or someone in the community that's able to do it. Now, for one thing, as I said, we think that that allegation is without merit and shouldn't be considered in making your decision. But the unfounded accusation that was made by the investigator, that's included in Kroll Investigations reports, should give you pause. It should be a red flag when considering the rest of the report. It's indicative of the problems with the town's investigations that contains inaccuracies and unsupported conclusions by the investigator. Trying to retroactively enforce a policy that didn't exist at the time is not in comportment with just cause or due process. The investigators did not speak to Sergeant Brennan's supervisor from the time in question to determine whether a rule existed, what the supervisor's expectation was of Sergeant Brennan or an SRO in general. And many of the concerns that address this allegation will continue to come up as we talk about some of the other allegations, especially the retroactive application of rules that didn't exist at the time that Sergeant Brennan took his action or did not. Next, the second allegation, the town alleges that Sergeant Brennan knew as early as 2015 that the accused engaged in what the notice identified as an inappropriate sexual relationship and did not report it to the chief. As a factual matter, this is simply not true. At that time, the victim only shared that she had a years-long, seemingly consensual relationship with Porter where both were adults. Nothing reported by the victim at that time, when she was already 25 years old, was illegal. Nothing reported Sergeant Brennan's obligation to make a report to DCF as a mandated reporter, and the relationship was over, and the two were no longer in contact. Sergeant Brennan did not possess any first-person information at that time that Porter engaged in any grooming behavior prior to initiating the relationship. The investigators' conclusions to the contrary and the statements of the town today are unsupported by the record, and they are dependent on hindsight. Now, with the information we know, with the information that the survivor has shared with this community, we can look back on that relationship differently. But at the time that Sergeant Brennan learned this information in or about 2015, that was not the context in which he would have viewed it. The department policy does not require officers to report mere speculation that someone engaged in legal but potentially inappropriate behavior. In fact, the town again only relies on a rule that did not exist at the time, citing General Order 2018-0004. It was not in effect at this time. Even still, the disclosure that Sergeant Brennan received at this time was not specifically covered by the terms. Now, in its notice, the town relies on Regulation 10.1, professional image.
Can I ask a question?
Yes.
I hate to interrupt, but I also noticed in that policy that it says, I agree with you that it doesn't apply retroactively, but it also says, and I want to make sure we discuss, that it's required to notify both the chief and the deputy chief, which would be problematic on its face.
Absolutely. So what I'll say, we do plan to kind of go into some of that a little later in my presentation, but I agree that the policy is incredibly rigid and did not foresee and did not predict a situation where the complaint would be about one of the two individuals specifically required to have the report made to them.
Can
And
I
in
clarify,
fact,
was Deputy Porter, was he the deputy chief in 2015?
This is
It's twen-
2017, when
Oh, I
we're,
thought we were talking about this one.
sorry, that's okay, but it's 20, you're on to 2017, right?
I think at the time I was still talking about 2015.
Oh, I'm sorry. I apologize.
It's my understanding that in December of 2015, Porter was elevated to lieutenant. In looking through the record, I think it's probably clear to you that the exact year that these reports happened were unclear to Sergeant Brennan in sharing this information. He knew the age of the survivor at the time that he received that information, so it could have been just before or just after Porter was promoted to lieutenant in 2015. But again, we'll talk more about the rigidity of the policy later. So to get back to this specific allegation, the town also relies in its notice on Regulation 10.1. What I think is important is that when you read the Kroll report, the investigator did not sustain a violation of Regulation 10.1 against Sergeant Brennan. Instead, it says that Brennan should have known that Porter's conduct would have violated that regulation, and that triggered his duty to report under the general order. Again, that did not exist at that time. There's no evidence that Sergeant Brennan was on notice at the time in question to report assumptions about an otherwise legal relationship. So at this time, we'll turn to the next allegation, that Sergeant Brennan knew in 2017 of an alleged sexual assault on a minor and failed to report it. First of all, I want to make clear the survivor did not walk into the station and file a complaint. The investigation report references the department's ability to receive anonymous complaints that's outlined in its IA policy, but it ignores another part of the same policy. The department's IA policy specifically directs officers who receive what it refers to as street complaints, complaints out and about, to tell the person to come forward to the shift supervisor. It does not obligate them to take the report themselves when they receive a street complaint independently. The victim shared this information with Sergeant Brennan based on the trust that was built before them. At this time, Sergeant Brennan will speak directly to the issue raised by this allegation.
Thank you, Dan. Excuse me. I ask you to consider the following additional information which provides context on why these events unfolded in this way. As you know, in 2017, when the victim was 28 years of age, she confided in me what I recognized at the time to be allegations of inappropriate touching and kissing by Porter when she was in high school and Porter was working as the school resource officer. At that time, what she disclosed did not rise to the allegation of rape. I knew that such an allegation and investigation must be evaluated by the Middlesex District Attorney's Office as the only prosecuting body for such allegations. Upon hearing this allegation, I strongly encouraged her to report this information to the District Attorney's Office so they could properly investigate her claim and evaluate it for prosecution. I also encouraged her to seek counseling. However, she emphatically conveyed she was not ready to report, and in fact refused to come forward at that time. She further stated that if I reported it, she would not corroborate that information. As I assessed what to do, at this point, I knew that there was a disclosure by a 28-year-old adult of past alleged inappropriate behavior by Porter. Where the survivor was an adult at that time, excuse me, this was not a situation where I was a mandated reporter. The mandated reporting law applies to people under 18 and over 65 years of age, where abuse and neglect are presently occurring. This was not a mandated reporter situation. The alleged conduct 13 to 14 years ago, the alleged conduct occurred 13 to 14 years ago, and I also understood that the victim was uncooperative in proceeding any further with that information. I understood that the victim and Porter were no longer in contact and had not been for approximately 3 years. I knew that the victim was worried about her safety if Porter found out she had told anyone, and for that reason, she would not further disclose. I also considered that there could be a severe impact to the victim if she was not in a position to testify and corroborate such substantial criminal allegations had I brought the allegations forward. I remained a resource for the victim, and I continued to encourage her to report the behavior to the Middlesex District Attorney's Office. For many victims, it can take years to come forward, and some may never report. Training and experience have shown me that trying to force victims to report against their wishes can cause them to stop communicating about the allegations or have other significant negative impacts to them in their life. If there was to ever be a fair investigation or prosecution and accountability, she had to voluntarily report the indecent assault and battery to the Middlesex District Attorney's Office. I also knew that if I outed the victim before she was ready to report the results, the results could be catastrophic for the victim as a classic example of re-victimization.
As I mentioned during our introduction, Attorney Elizabeth Keeley is an expert in investigating and litigating allegations like these. She submitted a written statement to the board in advance of this hearing. I understand you've previously indicated that you don't want to hear from any additional witnesses besides myself and Sergeant Brennan. I think it's important that you hear directly from Attorney Keeley. I also think that the town, in bringing forward these guidelines and making their own analysis of what is the standard around this issue, raises that question even more to the forefront. And I would ask if you'll allow that Elizabeth Keeley be allowed to give a statement at this time.
Didn't we all read it?
We read the statement, they're asking if she can speak. Yeah.
So I've read the statement, and I think we had ground rules set up before we started, and we said that there would be no witnesses,
I agree.
no experts.
Makes sense.
Okay, I'm sorry.
Okay, at times it feels like the ground rules are being forced in one direction at this point with the guidelines coming in, but I understand your decision and I don't want to upset it. What I think is important, and I'm glad that you've read Attorney Keeley's statement, she points out a number of very important things, and I hope you review it and consider it as you're making your decision. First of all, allegations of sexual assault often go unreported for long periods. Attorney Keeley shares that the guidelines and best practices encourage investigators to center victims in the process. She highlighted that adult survivors of childhood sexual abuse must determine for themselves whether and how they disclose past abuse, and that the safety and autonomy are integral into their ability to disclose this past abuse. As we discussed at the very beginning of our presentation, her safety and feeling of trust with Sergeant Brennan allowed her to come forward and make these reports. She set up guidelines about how that information could be shared. He respected it, and I think that that's important to consider. Attorney Keeley indicated that Brennan understood that directing this victim to bring her allegations directly to the district attorney's office was the clearest path forward for her and for any possible prosecution. And finally, Attorney Keeley stated, quote, "I believe that Sergeant Brennan's actions sought to protect and serve the best interests of the victim, and I believe he proceeded in a manner which exhibited true understanding, sensitivity, and compassion, despite an incredibly challenging situation. I encourage the Select Board to consider as they assess the incredibly difficult position Sergeant Brennan faced, as Sergeant Brennan truly acted in a victim-centered and trauma-informed way. That is precisely how we have called upon our law enforcement to act under our state's guidance on responding to allegations of sexual assault. Again, that's Attorney Keeley with her more than 15 years of experience in handling cases like this. Finally, two of the town's allegations focus that Sergeant Brennan knew as of August of 2022 of an alleged rape of a minor, and at the same time he knew that the victim was reporting her allegations and was concerned for her safety, and that he failed to report either fact to law enforcement. Sergeant Brennan, will you speak to this allegation?
Yes. In July of 2022, the survivor informed me that she was now ready to report these allegations to the Middlesex District Attorney's Office, which was the most appropriate agency to investigate her allegations. She contacted the DA's office and arranged a meeting to take place in August of 22. The day before this meeting, I met with her at her request to review her notes. It was during this meeting with the victim, the day prior to her meeting with the DA's office, that I learned that what she was reporting allegedly amounted to what the law would call rape of a child. I knew that proper notifications would be coming to the chief and the town within days, and instead of those coming from me, notification would be coming from an assistant district attorney or a state trooper with the Middlesex District Attorney's Office who had already begun the investigation and knew what information was appropriate to share. The Middlesex District Attorney is the top law enforcement person in Middlesex County. The Assistant District Attorney and the Mass State Police assigned to the District Attorney's Office would have been the agency to investigate this case regardless of where it was initially reported. At that time, I knew that she was terrified, and I continued to encourage her to report. I advised her to contact her local police and voice her concerns regarding her safety. The day the chief was notified, I met with Mass State Police investigators at their request to tell them what I knew and when. They advised me that they would notify the chief.
To follow on that point, I think it's important to recognize that the state police already knew that Sergeant Brennan advised the victim to notify her local department, and that he took efforts to help guide her and to have the people best positioned to protect the survivor to be in a position to do so. At this point, I think it's important to talk a little bit about the department's policies. The department's policies, regulations, and rules raised by the town fail to adequately address the complexity of the situation that confronted Sergeant Brennan. In particular, General Order 2018-0004 creates seemingly rigid requirements that even the chief acknowledges could not have been followed here. The policy required reporting an allegation to both the chief and the deputy chief. This includes the accused. Their phone numbers are in the policy. The policy does not contemplate the chief or the deputy chief being the subject of the complaint. And there's no reasonable expectation that Sergeant Brennan was required to report this directly to the accused. Going around the deputy chief in this case was also complicated by the perceived personal relationships that he had with the other members of the command staff. The accused and then Chief Lee, through 2020, appeared to be close. There was some understanding that they had potentially vacationed together. There was a perceived relationship between the two. The accused and Chief Bennett previously socialized outside of work. Chief Bennett told the investigators that they were friends. I'm told that the relationship may have soured to some extent in recent years, and I don't say that I have personal information about the relationship between them. But Chief Bennett, in his interview with Kroll Investigations in February of 2023, still identified himself as the accused closest confidant in the department. It's not unreasonable for there to be concerns about bringing this allegation forward within the closed confines of the policy. The policy did not allow for an outlet for an officer to bring this to outside officials, to go to an outside agency like the district attorney's office, who may be better prepared to handle the issue. And I think the complexity of the situation that Sergeant Brennan confronted was also understood by the town. We heard from the chief that he was told by the DA's office to not share the information they gave him with Blackstone Valley Tech. There was control by the DA's office over that information to preserve and protect the investigation and the prosecution. And the chief complied with that, from my understanding. That information was not shared for months. That was a situation because this is incredibly nuanced, complex, difficult situation to be in, with a lot of competing interests to take into account. The town's contemplated discipline here, the recommendation from the chief, is not supported by just cause. That's the standard that we have to meet. It's a term of art in labor law. One of the ingredients, one of the keystone principles in just cause is due process. 3 out of the 5 allegations levied by the Loudermill notice rely on the retroactive application of rules that did not exist at the time of the alleged misconduct. The town cannot show that Sergeant Brennan was on notice of these rules or expectations at the time in question. The rules just didn't exist. Moreover, workplace discipline is meant to be rehabilitative, not punitive. This process is meant to determine the lowest level of discipline necessary to make sure that Sergeant Brennan will comply with the department's expectations in the future. Discipline should also be progressive and comparable. Importantly, a review of the department discipline over the past 20 years shows that the town has consistently followed progressive discipline principles and has never issued more than a modest suspension to an officer without prior discipline. More appropriate action here could include additional training, and it could include policy reform to clarify expectations for everyone and to make sure in the unlikely situation that such a difficult situation arises again, that the department is better capable of handling it. I also ask, in making your decision about the appropriate level of discipline, to consider the totality of the circumstances here. Sergeant Brennan was placed on administrative leave over 8 months ago. On paid administrative leave, he continued to receive his regular base pay. But a key ingredient of officers' compensation is overtime compensation and pay from outside details in the department. It's still concerning that months after the investigation began, Sergeant Brennan sat for his interview. The initial report was issued by Kroll Investigations, by what's included in here, on February 28th of 2023. Sergeant Brennan was still working. He worked through January. He worked from August, September, October, November, December, January, February, March, April, and he's put on leave in May, after the report's already been released for months. We haven't received a satisfying answer as to why that happened, but it has caused an immense amount of financial impact on his family, stress for his family. He and his family have been impacted by the misinformation and public scrutiny that has been applied to the situation, in which frequently news articles will uncritically include his name next to the accused's name without a distinction between the accusations that have been made. It has harmed his reputation, and he's been painted with too broad a brush. Sergeant Brennan has been committed to this community for a long time. And I know before I conclude, I want to make sure that he has a chance to say how important this community is to him.
I have lived in this town and have been an active and engaged community member for 24 years and worked for the town for 22 years. I have volunteered as a coach. I was on the growth study committee with some of you members. I've been involved with the Scouts, and I have been on the Little Hopkinen Little League Board. I have held six different positions while working for the Hopkinen Police Department. While I'm a police officer, I am also a human being. A human being who has made thousands of judgment calls over the course of my career. In every one of those decisions, I have tried my best to be fair, treat people with respect, help others who can't help themselves, and support those who have been victimized. More than anyone, I am deeply aware of the different factors that complicate this situation that we are talking about here tonight. But I ask you to thoughtfully weigh the various facts that have been brought to light by Attorney Fogarty, Attorney Keeley, and me. I ask you to consider the implications of your decisions tonight. What impact does it have to terminate an employee with no prior discipline and who helped clear a path for and support a victim to bring an alleged crime against one of our own officers in a manner that would allow a fair and impartial investigation and prosecution and allow the victim to maintain control of how, when, and if she shared those allegations? None of us likes the fact that the alleged crime is against a former officer of this department. The fact that a member of the command staff from our community who wore the Hopkinen police uniform and badge has now been accused, investigated, indicted, and arraigned for 3 counts of rape of a child. This is traumatic, especially for the victim and also for our entire community. A court of law will decide how his alleged crimes will be handled. But as a town and as a department, I think there's an opportunity for us to all learn as a community and as individuals from this entire devastating series of events. What will we take away as practical and meaningful improvements to the way we lead, the way we select our leaders, how we pay attention to those around us, how we deal with difficult conversations, how we interpret policies, how we make ethical and moral decisions, how we support victims, and how to engage in conversation that leaves space for multiple truths, but also decisive action when necessary. These are all questions I have grappled with throughout my career and still contemplate, as the answers are not always as straightforward as we would like. Given the highly unusual circumstances where I try to act in an ethical and moral manner, trying to protect the protect the survivor and provide the best chance for justice, I realized that my actions did not meet the expectations set by certain department policy. I hope to never be in a position like this again. But should I be, it is clear I will evaluate other alternatives to ensure the town is kept apprised and that relevant policies are followed while also keeping survivors safe. I look forward to getting back to work and serving the community in our department as I have been for the past 22 years. I am passionate about helping the people of Hopkinton and look forward to helping the department and its officers move forward together. Thank you very much for your time.
Sergeant Brennan confronted an incredibly difficult situation. What Attorney Anastasopoulos has referenced is hard work. We don't dispute that. But he addressed that situation by relying on his experience and his training to make the best decision that he could, which centered the survivor and helped her ultimately report allegations to the appropriate investigative body. It's not clear to me that had he acted differently in 2015 or 2017, that the DA's office would have been in a position to adequately investigate the allegations and to discover the truth. We thank you for your time today, and we ask you to seriously consider the facts and issues we've raised in making your decision and to return Sergeant Brennan to his position within the department. Thank you.
Thank you. Okay, so as a board, I propose we talk about the policies and our questions. I don't know if there is a particular process. I reviewed the policies myself. I came to some of the conclusions that the policies don't necessarily apply. I don't know if we want to go through them one by one, or if you want to just ask the questions that you came with.
It's up to you.
Do we want to just start with our questions, or? Okay.
That's a good idea.
Okay,
I'm fine.
all right. I'll start. The first, I have them sequentially in front of me. So the first policy is the UNUA as of 2021, August 21, 2022, of the alleged rape of a minor and failed to report it. Attorney Fogarty has talked about the difficulties in those policies. I came to the same conclusion. I don't think that attention to duty necessarily applies. I'm open to hearing how it does. I don't think IA 401 applies. That's when somebody comes forward with a complaint to the police department, and the process there, it includes the complaint procedure. And then the General Order 2018-004, which was the duty to report through the chain of command. The complicating factor was that it mandated that the person report to both the chief and the deputy chief, who was at the time the alleged perpetrator of the crime. So I would feel much worse about this if, in my opinion, he facilitated the connection, that the survivor was ready to come forward. He facilitated the connection to the DA, which is, as we know, a legitimate law enforcement agency. As we've learned, the most appropriate law enforcement agency to report to, and she was in their care, and they were taking over the investigation. So I think that in that case, even if there was a violation, it would be minor. I don't know that I personally see the violation in that case. Moving on to the 2017, I don't necessarily see how the policies apply here either. There was no complaint against the police department, or a police officer in the police department. I also don't see how necessarily attention to duty applies. And of course, General Order 2018-004 was not yet in effect in 2017. However, I will tell you candidly that that this is where I have my personal area of greatest struggle, in knowing that that something somehow should have been reported, whether or not it applies to policies. So I don't want to parse that term, but you know, I have questions about 2017, I guess is what I'm saying. And if I were to ask my most important question, Sergeant Brennan, it would be, did you fail to report this alleged sexual assault on a minor to protect a fellow police officer?
I did not. Jay Porter and I have had a contentious relationship for a long time, and there was no intention to do anything other than to protect the victim until she was ready to come forward on her own.
Okay, I have one more question right now. Did you fail to report the alleged sexual assault on a minor to protect your own career?
I did not. My sole purpose was to protect the victim and hope that, as her calls to me came in, that I was continually trying to encourage her to report the allegation. And there was never an attempt to cover up for myself or for for John Porter. It was solely for the victim to come to her own conclusion to report.
I know I have another question, but I'm gonna wait on that for later. The third policy was in August 2022. The victim was pursuing a criminal investigation and was concerned for her safety. I have the same feelings as I did for number one, in that she was in the custody and care of the district attorney, which was where her case and complaint was rightfully being handled. So I don't have the same concern with that one. And understand that it is complicated. Again, we still did not have a complaint to the Hopkinton Police Department to pursue. I don't want to parse terms. If the complaint hadn't been brought forward to the DA, I would have trouble with the fact that it hadn't been brought forward to Hopkinton. The fourth is in 2015. That the accused and the victim had engaged in an inappropriate sexual relationship and did not report it to the chief. Again, the policy that is cited came after the alleged incident. Honestly, I think we can all agree that that behavior is problematic from many levels on the part of Deputy Chief Porter. I guess he was, I don't know what he was at the time, I'm not gonna try and guess. But it was an adult consensual relationship that, in hindsight, probably sends off a lot of warning signals when it happens, but in hindsight, we see it more clearly. But it was two adults, and I'm not sure that there was anything that Sergeant Brennan was obligated to report, and we'll never know if it would have helped in any way. And the final one is that you use the victim as the survivor as a babysitter when you were a school resource officer and did not obtain prior approval from your supervisor to do so. Again, as Attorney Fogarty pointed out, Sergeant Brennan was a school resource officer in 2005 to 2008. The policy that they cite went into effect in 2017. So I don't think that we can consider that as in any way problematic. So those are my initial questions. I'll turn to Mr. Manan.
Thank you, Madam Chair. Thank you, Mayor. I just have two clarifying questions right at this time, and then let my colleagues move forward, and I may come back later. One is that I got a little confused. So my understanding is, and the documents, unfortunately my laptop is not working,
I have
that
them.
Deputy Police Chief Porter was appointed in 21. Is that correct?
Yes.
But we heard several times that 2017 was not applicable because the policy says to report to chief and deputy chief, but Porter was not deputy chief at that time. Is that correct?
He was not. It's correct that he was not the deputy chief at that time. I think part of our concern with 2017 is that the policy that you're referencing was issued in 2018. So we have concerns with the 2018 General Order 2018-004, 300004, in that it rigidly requires reporting both to the deputy chief and the chief. In 2017, that policy didn't exist yet, but you're correct to say that Porter was not yet the deputy chief either. He was lieutenant at that time.
Thank you. And in general, I'm trying to understand the thoughts and actions, which is, what was the thought? And what I mean by that is, I'm not a lawyer, I'm not a law enforcement trained officer, so I'll just ask simply as the position I'm in from there and that perspective, which is, what was going on in your mind as the possible resolution of this, knowing what you heard and knew progressively from 2015 to 2023, Sergeant Tim, that how did it get resolved? In other words, if a police officer, knowing all these that you knew at that time, does not come forward because the boss is the perpetrator or alleged perpetrator in this case, what is the solution for our society? So in other words, if more things like that happen tomorrow, that someone's boss or boss's boss is involved somehow, is the standard that it's okay not to report because it's a difficult situation? What, in your view, would be you were expecting that someday the victim would come forward, and if the victim doesn't come, we all die with this, and this case never sees the light of the day?
I want Sergeant Brennan to answer this in just a moment, but two things that I want to say is first of all, I think what we've heard is that Sergeant Brennan worked incredibly hard to encourage and promote the survivor to bring her story forward. He didn't just ignore it. He didn't fall back on it. In his communications with her, he continued to encourage her to bring her story forward and to share her accusations, her allegations with the appropriate investigatory body. So he wasn't prepared to just let it go, but he thought what was most important is that the survivor be the one to come forward, and that without her, a full and fair investigation wasn't going to be possible. And I think, how do we confront this going forward from a policy perspective? I mean, some of the things that I think are necessary. This policy did not involve any other town personnel. Going to the town manager's office was not an option in the current policy. It does not involve going to outside agencies, the district attorney's office being one of those options, or others, federally or in the state level. And so I think reforming the policy to provide opportunities so that when a survivor is prepared to come forward with a difficult accusation against a member of the command staff or a high-ranking officer in the department, the policy gives clear guidance about how to avoid those conflicts and ensure that a report is made. And I think that that's a way that we can move forward from this.
Thank you. And my last, sorry.
I do. So my experience is mostly stemming from 30 years of teaching the RAD program. Many people in this room have gone through my RAD program and seen how I teach and the passion I have for that program. What I've realized over my career is that victims of sexual assault and rape, what they will do sometimes as they're reporting is they'll give you a little piece. They want to give you a little piece to see, what are you going to do with it? Are you going to keep it to yourself? Are you going to honor my wishes? Are you going to report it right away? How are you going to report that stuff? So I did feel sometimes as if, she told me what she told me in 2015 to see, am I somebody that can be trusted? Is she going to talk to me and things like that? So I think that's important to know, that a survivor will give you just a little bit along different times to see, are you going to respect their wishes? Are you going to support them? Are you going to help them? And I think that's sometimes what the survivor was doing in this case.
I apologize. I just don't want to get too far afield, because I think the chair asked a series of questions, and now you've asked a series of questions. And I think if we don't start to address some of them, particularly given that response that we just heard, I think Attorney Fogarty used the word emote, and the efforts that Sergeant Brennan went, and he just described. The victim will give you a little piece to see what you do with it, but I can't help but conclude that what the survivor wants you to do with it is something. And so we have these series of meetings, we have these series of coffees, we have these series of chats where we're getting bits and pieces. And what we know during this entire period of time, Sergeant Brennan does nothing with it. So at some point, she's either giving you this information to see what you do with it, honor her wishes or not honor her wishes, but there's this continuing discussion. We just heard either from Attorney Fogarty or from the sergeant directly that he was trying to pull this out of her. He's trying to pull it out of her. Meanwhile, there's a piece here. The criminal justice system and everything that happens in the criminal justice system is one part of the equation. That isn't our part of the equation. Our part of the equation is how we hold each other accountable and what we do internally in our police department vis-a-vis each other as employees. I don't take as casual this consensual relationship when somebody maybe it's just me, when somebody knocks on your door, on your dorm room door, on their 18th birthday, and it's an adult male that was your SRO. It wasn't some random person, I kind of like him, or let's chat, and now that I'm 18, they show up. It isn't a random occurrence that she's relaying to you. It is specific to someone that was her SRO, that clearly there was a relationship between the two of them. He had taken interest in her, and she shows up. It isn't something in isolation that we can just shrug. The other piece of this is, we know you asked the question, are you protecting my career? I heard the answer, but we've all read the transcript. If you could do anything differently, what would you do? Well, if the victim was willing to come forward, if the survivor, and there was a different term used, if she was willing to come forward, and he wasn't my boss. And he wasn't my boss. So this idea of, interrelationships, and does the chief, the suggestion that there was a friendship between the chief, and let's think about the chiefs involved. When this first happened, and the concern, if somebody, our sergeant, can't figure out a way to read that policy, the application of it, particularly in 2022, and not realize I don't have to tell the person that's also on it, that's the perpetrator, that I can go to my chief, or that he doesn't understand that there are other resources in town hall, with HR, with the town manager, with town council, with his own labor attorney, with his own attorney. Hey, I'm sitting on this. This person is outside of the bargaining unit. I need to come forward with it. This is what's going on. For years, we watched this person work in the department. And there's no question in terms of his testimony. I would have done something different if you want to come forward. Now we're hearing we're trying to pry it out of her to get her to come forward, and he wasn't my boss. So that's not an accurate answer. The other thing that I want to point out also is that the notice.
No. 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 You guys are going to be asked to leave if you don't just sit quietly, please. And I don't want to do that. Everybody's entitled to be here, and I want you to stay. But we have to stay quietly, and we have to stay composed.
So the issue, I guess the issue is, it isn't a question of the victim coming forward, and we all appreciate, we all agree that it would be on the survivor's time. The issue is the period of time that Sergeant Brennan knew, particularly, and the application and the nuance. There are other rules and regulations, 3.0 in the Department Rules and Reg, that specifically that he signed off on, that were in place, that specifically talk about common sense, right, and the application of that. And sort of the common sense application as a police officer, understanding what obligations are when you find out that somebody has been, a 14-year-old has been fondled and kissed, and not doing anything. That's the problem. The problem isn't the criminal and getting this person to come forward. The issue is, what do we do internally in the department?
The department policies also recognize explicitly that they can't cover every situation. We're hearing today that he should have used common sense, but that they're strictly adhering to certain policies. They want to refer to these policies and then walk away from them and say, well, he should have known what the policy's intention was or what it meant. That's not notice. That's not due process. I also want to point out that I think that the town is mischaracterizing what Sergeant Brennan just talked about. Not that he was intentionally in the moment, or at least as I understood it, trying to pull it out of her meeting to meeting, right? Especially between 2015 and 2017. But rather, looking back now, he understood that this person felt comfortable in confiding with him because he followed and respected her wishes and her ground rules and her boundaries in this conversation. And we think that he was doing the best he could in that moment. Even though sitting here today, he's recognized that he understands how that didn't live up to the expectations of department policy.
So I just want to make it clear to everybody that we are going to be really intentional about hearing from everybody on everything. And if it doesn't appear that way, I promise you that every one of us up here wants to hear from everybody here who's entitled to speak equally. And also, I started my conversation on the policies. I don't want anybody to get too caught up in the fact that that's where any one of us reasonable people is necessarily, hovering, right? policies are policies, and they may be flawed, they may not cover, they certainly never cover every situation. But in this case, it's important to talk about them because they're being cited to support the recommendation to fire Sergeant Brennan. So we have to at least have clarity on how we feel about the application of the policies, but also the conversation is broader than that for sure. Shahidul, did you get all your questions asked?
I think I had one last one, and it's kind of related, which is I didn't fully understand why, if there were concern about the chief and deputy chief, why didn't Sergeant Tim went to the state or the AG office? You mentioned something. Sorry if I missed it.
What I think that I said to that point, understandably, there were other options. Those options wouldn't have complied with policy, which is one of the things that I think is important. The town's relying on this policy, and that policy was incomplete and didn't address the moment. That's one of the things that I think is important for the board to recognize and deal with. Sergeant Brennan could have gone on his own to those other agencies, and I think a lot of what he shared here tonight as a reason why he chose not to do that is because the survivor was clear that she was not prepared to move forward with that she didn't want him to do that she was unwilling to corroborate any complaint he brought forward on her behalf in that moment. And he understood, or it was his perspective, that doing so would not advance an investigation or a prosecution. It would not advance her safety or her ability to bring her allegations forward in her own time.
The only thing I just want to point out in terms of coming forward to a chief, and very early in this process, that was an obvious question that was asked. Why didn't you come forward? And this idea of a friendship and a connection between the chief and the deputy chief, right? All I can do is point to the two things. All I can do is point to the record that this idea of friendship, I don't think there's anything about Chief Bennett that would suggest that would transcend his duties and obligations, and you need to look no further than the fact that he was advised not to talk about this. And I think in a very early conversation with the state police, he was told not to even tell his town manager or council. That isn't what he did. If the genuine concern in how he would act would be what would he do with that information, he immediately informed the necessary parties, even if they were best friends, which they weren't because there was suggestion, well, they were buddies and then they sort of had a falling out. But more importantly, as you think about this, he was a lieutenant in 2017. I'm not even sure if he was a lieutenant in 2017. The chief at the time was Ed Lee. It was a different chief. So this idea that there was a friendship and you couldn't go to this chief because there was a friendship between the two of them with Jay Porter, does that extend to Chief Lee? And if there was to what end? How many chiefs? There was another chief at the time when he first found out, the first truly, even assuming when the person was 18 years old, it was a consensual relationship. There is no doubt in 2017, it was a different chief. And are we parsing here over kissing and fondling a 14-year-old versus penetration of a 14-year-old? And that being the trigger, well, this is much worse. Now I've got to do something with it.
We're never going to parse that term, by the way, that situation.
No, but here's what
Offensive to suggest it, right? We're never
but
gonna do
here's
that.
but here's the problem. What we don't know is what the department struggles with is during this entire time, the assumption that the department couldn't have helped or the department couldn't have done something to deal with this officer on our payroll and to look into it and to monitor it, completely cut the department out, and in the interim, potentially creating huge liability for the town. We have this person working every day, week after week, month after month, promotion after promotion, and we have one of our own members knowing what he knows and watching it happen and exposing that liability. The town was specifically denied the opportunity internally to either assist or to deal with potentially a problematic, and now we know, an indicted and arraigned on 3 counts of rape.
Shahidul, don't let me put words in your mouth, but I think you were asking about reporting alternatively too, right? Was there other ways to report, even if you weren't comfortable going? Is that?
That's correct. That's the kind of heart of that question, that, sitting on such an important information and sensitive information, And even if the perceived hierarchy challenges are there, even though it was refuted with some more data, I'm finding it hard to reconcile why wouldn't any other venue be explored, especially if the victim can go to the AG office, anyone can go to the AG office. So that was the kind of sense.
Yeah, and I appreciate that concern. I think that there's two different questions here. There's why didn't Sergeant Brennan do that, which I think is important. I think he's shared some, and I think he can share some more in a moment. But there's also, is it a fireable offense from this town for having not chosen to do that? And so that's why it's important to recognize what were the policies and expectations that were shared. None of them required him to go to an outside agency. None of them gave him that avenue as to a way of successfully complying with the policy. So is that a reasonable grounds for discipline here? No, I don't think so. But the reason why he chose not to, I think, is more complex and more about his decision, his effort to cultivate or to promote the survivor's ability to report her own story. Is that correct, Tim?
100% right.
Thank you.
Amy?
If I could,
Yeah,
I'd like,
oh, yes.
I'd like to address some of the conversations here. First off, the assumption that I wouldn't do my duty because of some false insinuation that there was a friendship that would cause me to not do my duty is just untrue. Actually, there's people in this room that I came to this town 30 years ago that I am closer with, that are directly in Sergeant Brennan's family than anybody that I've ever met since coming to Hopkinton. So that's blatantly false. You know, when I got here in 1993, they gave me this manual. And if you ask Sergeant Brennan, he has this manual. We all got it. This is what we worked out of. This. We now have 276 policies that try to guide us through every possible scenario, but they're guidance. This document here serves to give us broad guidance, to tell us that we have expectations, to tell us what professional conduct looks like, to make sure we don't to have conflict of interest problems. These are the rules and regulations. Our policies and procedures are vast. They encompass 2 5-inch binders, over 276 policies. But at the core, when Sergeant Brennan and I got here, this was the guidance. And if you look through this book continually, in many rules, it sets the expectation of what we're going to do. If we don't expect that a police officer is going to report a crime committed by another police officer simply because there's no complainant, because someone hasn't walked into the lobby, we're done. We're done. There will never be another fellow officer reporting about another fellow officer's wrongdoing. In fact, I mentioned in my report, if you go through our RA files, you will see that most IAs, and even those that resulted in suspension, came because officers observed inappropriate action and brought it forward. I'm proud of that. I'm proud of the history of the Hopkinton Police Department. As I said, we hold each other accountable. We do. On the topic of, I'm sorry, getting old. On the topic of progressive discipline, I'd like to tell you that if Deputy Porter was here, I would fire him for the first violation of rape, for the first violation of sexual assault on a child. I would fire him. I wouldn't give him a written warning.
That's a felony. Come on.
So look, if we have to
Please,
take
audience.
a break, we'll take a break, but I'm hoping we can all stay quiet.
So
No, wait.
So
hold on.
if I can though, I think it's an important point because at some point I want to respect and answer all of your questions because it's going to help you form ultimate. I started off by saying you're going to have a difficult decision tonight, but I think the point that the chief is making is that I don't disagree with Attorney Fogarty. There is this concept of progressive discipline, but there is this sort of concept of, the chief said I wouldn't start at a written warning, a verbal or 1 day. So there are times and there are instances and there is behavior that unfortunately for that person's career, it warrants termination. and what the chief is articulating, and it's the circumstance that is difficult with Deputy Porter. And believe me, there was a lot of discussion on what we do with Deputy Porter and how soon we start to do that to Deputy Porter vis-a-vis his continued employment here in Hopkinton. But the important thing for the board to understand is there is no preclusion or requirement of a multi-step disciplinary procedure. If you feel that the actions here or the inactions here, however you want to characterize them, are of such a nature that there is no ability for this individual, this officer, this employee to come back, right? Discipline is, in fairness to Sergeant Brennan and to the process, discipline, the purpose of discipline is to be at a level that ensures correction of the behavior. There are times that correction is impossible. And so that's what you're going to have to sort of deal with, but that is sort of the continuum, and that is the test.
Understand?
I need to respond just for a moment.
Sure.
I know we heard from the crowd that's assembled here today, but this is another example in my mind of the false equivalence that's continued to come by in the media and in some of the town records, wherein there's a comparison to discipline that would be appropriate for someone who is accused and has been indicted on several felony counts to what happened in this situation. And, we think that we have we have tried to present the difficulty, the complexity, the nuance of the situation that confronted Sergeant Brennan, to engage with you on what the policies and expectations would be, both by the written rule and both by common sense, but to kind of reduce it now to a comparison to the accused in this situation, I think was wholly inappropriate. And it's important to say that here today.
We're going to take 5 minutes. I'm going to take 5 minutes.
We're going to take a 5-minute break at this point. Everyone's free to leave, come back, use the facilities, whatever you need to do.
Taking a break.
Thank you.
Make the announcement about the BMW.
Yes.
They offer everybody one, but I can only find one in the bottom.
So folks, we're,
Oh, some mints too, if you want.
They're bringing them up slowly, so maybe they're not up yet. Now you are. Yeah.
So folks, we are going to start again. Before we do, I just wanted to let everybody know that we were told there is a BMW in the parking lot with its lights on. Dark blue, black, but if you parked in a BMW in the parking lot, I suggest you go out and just make sure your lights aren't on so that you can leave tonight when you exit.
We'll say it again.
Ryan, I don't think anyone heard you.
Yeah, we'll say it
No,
again.
I don't
Yeah.
Yeah, your
Yeah.
microphone is
I know,
working.
but you know what? That's a way to get them to pay attention.
We have your attention, please. We have your attention, please. As Brian just reported, there's a BMW in the parking lot with its lights on. So,
Blue.
we think it's dark blue or
a
black.
dark blue one.
All right, Amy.
Okay. If we're just doing questions, I don't particularly have any questions that haven't already been answered. I did read all the documents and listen to everybody carefully. The only thing I wanted clarified, which Shahidul already asked, was the timeline, and that Chief Lee was the chief from 2014 to 20. I wrote it down, hold on. But he was not the chief, or Chief Bennett was not the chief until 2020. And Deputy Porter was not the deputy chief until 2021. So that was clarified, so that was really the only question.
All right.
If I could only, and I
You
apologize.
know what? Actually, can we go to Mary Jo, because there was no questions yet, and then we'll come. What is it?
Well, there was the comment about the false equivalent, and then because of the, the decision was made at that point to sort of take the break, but I think at some point I do want to come back and talk about that false equivalent. Okay?
I'm totally coming back to you. Okay. Mary Jo.
I just want to say that, can you hear me?
Yes.
Okay, I just want to say that as a selectman, this is probably the hardest thing I've done so far. Very, very difficult. And I have read everything all week. My eyes are going like this with the computer. But I have some questions. And one is, nobody ever mentions her parents. Were her parents ever notified? Was the mother notified? Was the father found out that their 14-year-old daughter was in trouble? By anybody? No? Okay, I also feel,
Just to, not to answer that
Yeah.
question directly, but just to clarify that the survivor was an adult at the time of every conversation that's relevant to this point with Sergeant Brennan.
okay. In your interview, when asked about talking to a chief, you said that you and the deputy were up for the same job, period. Not, that's why, or that's not why, or this, you're up for the same job, so you can't say anything to anybody? That just didn't ring right with me. I also felt that not saying anything, having been a member of the select board, not speaking to a chief, you could have come to the head of the chairman of the board of selectmen, you could have gone to town council, somewhere where we would have known that there might be a problem up the line with this man that we kept promoting. We promoted him to lieutenant, not knowing that there was anything that could have been a problem. We promoted him to deputy chief without knowing that there was anything that might be a problem with children. And we just gave him more and more power because we didn't know. And I just don't think that that's right. I think that the chief should have been notified. One of the chiefs, Chief Lee, Chief Bennett, you can have a private conversation with them and let them know. And then when it came up for all these promotions for Porter, we would have had something else to think about. And he may not have made it. And you just gave him more and more power. The higher he went in rank, the more power the man had. And if he had done this to a 14-year-old girl, And somebody knew about it, and nobody said anything. The rest of us were kind of made responsible because we promoted him. And I really find fault with that. That's because the whole community let us continue to promote this guy, whereas we probably shouldn't have, and we might not have if it was reported to somebody who would then let us know as the Board of Selectmen. That's a difficult thing for me to deal with. And I think, like I said, this is the hardest decision. Everybody really likes everybody. Everybody has good feelings to this town. But I really feel that you didn't give us a chance, or the chief a chance, the department a chance to do right because you never told anybody. And that is a problem with me. That's all.
Okay, so I just want to start by saying I am not in the least way equating you, Sergeant Brennan, with Jay Porter.
Yeah.
These are vastly different cases, and I feel it's my job to kind of look at this from the perspective of how the police department is going to operate. And with that, I think Mary Jo really summed up a lot of what my questions had to do with, which is really, how could you allow a sexual predator to keep advancing? Knowing that there was a way to report within the department to prevent that from occurring. I know that as a select board member, would have loved to have known that there was a sexual predator on our police force, and we were considering promoting him.
But one thing that I think is important to respond, because I very much appreciate those concerns, especially from the board who has kind of gone through these proceedings, who is, members who may have been involved in making those decisions. We don't know what would have happened had people acted differently in the past. I think what we've shared, what Sergeant Brennan has shared in his statements and in his written statement, was a sincere concern throughout this process that coming forward without the survivor supporting or corroborating the allegations would not lead to justice, would not lead to a fair investigation, would not lead to ultimately potentially supported findings, but instead lead to allegations that could not be substantiated, were not supported by anyone with first-person information, and likely dismissed at the time, because there wouldn't have been a situation in which anyone with the power or opportunity could have held someone accountable. That was his concern. Whether that's true or not, we'll never know, and I appreciate that concern, that we can't know, right? But I think he operated in good faith with that concern, and so instead of coming forward without her, instead of forcing her, outing her, sharing her information without her permission, he continued to encourage her to make those disclosures. He continued to show compassion. He continued to create a trusting environment in which she could open up and come to terms with what had happened to her in a way that would lead her ultimately to a situation where she could report and this individual will be investigated and potentially held accountable.
I certainly appreciate that. I certainly appreciate that. But as I stated, this is coming from the position of, from the perspective of how is our police department going to operate. That's and allowing a sexual predator to keep advancing. That's where I struggle with this. And it actually leads me to my next question, which is actually for the police chief, which is that if to Chief Bennett, if a report were made against, let's just assume that he was your deputy at the time, if a report were made, is there a process or is there a procedure that would have taken place that would have allowed Sergeant Brennan to continue to build trust with the survivor, but at the same time prevent the sexual predator from advancing his career?
Yes, there is. Yes, there is. I think the distinction that we keep making is there's the criminal case, and that if Sergeant Brennan had come forward, the criminal case might not have taken on any different pace. But what would have happened is the department would have stood with her and supported her. As I said before, reports would have been done. Any potential evidence would have gathered that is now lost. And we would have shielded her. But in a separate silo, would have been any investigation we could do to determine information that was out there relative to the accusation against Deputy Porter.
Sorry, that doesn't really get to my question. My question is, so Sergeant Brennan had built a position of trust with the survivor,
Okay.
where she felt that she could come to him over the period of 2015 to 2022,
Yes.
right? He had created a warm, welcoming environment where she could trust him. Could that trust have been maintained had he reported? Where, let me, where, and I'm not asking the audience here, where he could have continued to develop that, but prevent the sexual predator in the department from advancing. That's really what I want to know.
Absolutely.
I kinda
As,
wanna just make sure we talk in terms of alleged.
Alleged sexual predator.
absolutely. We would recognize the trust relationship that Sergeant Brennan clearly had. And he would continue to serve the department and to serve her in her wellness care and moving through the process. Absolutely.
Thank you.
So if I could be heard on that issue.
Sure, go ahead.
I think it's important to recognize, and as the record already establishes, that until August of 2022, the survivor made it clear to Sergeant Brennan that were he to share information that she shared with him, with anyone else, she would not come forward. She would not support the reporting. She would say that what he was saying was not true. She would not corroborate the complaint made by Sergeant Brennan if he were to repeat it. There is no way in which he could have maintained her trust with reporting this to the department. Doing that report to the department would have broken the relationship that he had created with her, and the department would not have been in a position to hold the accused accountable to take adverse employment actions against him without sufficient evidence to substantiate the complaint.
But we could have prevented advancement.
It's not clear to me how that's true. I also think it's important to note that since 2020, when Chief Bennett was promoted, even as lieutenant, he was still the second in control of this department. He had the same power. He received a title in 2021. I think that that's important to note.
Okay,
So-
thank you. I appreciate that. Go ahead.
Yeah,
Yeah.
so,
I just have one last thing. Please continue.
so I think on that point, and I think what the chief is trying to convey, that, I've seen nothing in my time here to suggest to me that this department could not have competently and appropriately handled these issues and concerns, even if that meant farming it out. The chief said, we could have done something in the words covert. You know what I mean? There could have been other things. To your point, that relationship could have been maintained. But, I want to go back to that false equivalent. It isn't a false equivalent. We have two buckets, and they're both significant. In the one bucket, you have allegations of horrific criminal behavior, and in the other bucket, what we are saying is that there's an absolute oversight on the obligations that officers have to each other. I'm not quite sure how 10.0 doesn't apply when it talks about employees shall not withhold information on criminal activity from the department or other authorized personnel. I mean, and that's a policy that I think the chief held up. There's no reason for the sergeant to not believe her. There's no reason for anybody in this room not to believe her unless and until other facts come forward, and that'll happen in the criminal justice system. There's no reason if he believed her that there wasn't something that the department could have done, and again, I stress, with our employee. That's the issue here. It isn't, we obviously have concerns with the criminal justice system, and does that case get better or worse? That, you know, there's a lot of discussion, but we'll never know the answer to that. There seems to be a lot of assumptions that the way it played out is going to be better. There's no guarantee of that either. I've never heard, you know, for the attorneys in the room and on the board, I've never heard somebody say, oh, a case gets better with time. Never once has that been said, uttered by an attorney. Never once, because it doesn't get better with time. An assault that happened when somebody was 14, even with the statute of limitation being what it is, doesn't get better when that person is 35. The chief was talking about the possibility of looking into records, emails, telephones, to the extent that they existed. All of those were precluded, not only to the criminal prosecution, but to the concerns at the end of the table in terms of this person's progression and the work that he did for the department. Thank you.
Thank you.
Sergeant Brennan didn't have a trove of evidence in his possession that he failed to turn over. He had his own recollection of a conversation he had with someone who was going to be unwilling to back it up. He wasn't in a position to share telephone numbers. He wasn't in a position to share emails. He wasn't in a position to share anything except these statements that she would have said were not true. There wouldn't have been an opportunity for the department to collect evidence and preserve it for some later time. There wouldn't have been an opportunity for the department to try to have their cake and eat it too and create this relationship where she doesn't feel like the information's been shared with anyone within the department, but yet still they're able to take adverse employment actions against this individual who's been accused of terrible things. I think it's important to remember that we're not here to try and recreate what happened or what could have happened and which was better, but rather to evaluate the decision-making process of Sergeant Brennan, who had good faith concerns about the alternatives available to him and made the best decision that he could in a way that he thought protected this survivor and protected the opportunity to bring the accused to justice. So in doing so, we believe that he should not be disciplined and he should not be terminated.
Thank you. I appreciate that. My last question is getting back to when you're saying these policies did not apply. How can I say this gently? But I don't buy that. When the policies came into existence, don't you believe that there was a duty to report? So in 2017, we became aware, you became aware of the rape of a minor, the allegation of a rape of a minor. In
Not true.
2017?
That's not true.
A sexual assault. Please, audience. Please, I'm not talking to the audience.
So we really
So-
won't get there if we keep getting interrupted this way. You have to bear with us. It's hard for all of us.
So when you became aware of the allegations, the policies were not in existence, correct? Right. When the policies came into existence, did you think it didn't apply to report what you knew from before?
If I could comment on a few things, I want to thank you for acknowledging that the misinformation in the public was devastating to me and my family, unacceptable. And nobody from anyone, the town or anyone else, sought to correct that impression in the public, and that was very difficult. So thank you for saying there's a difference between
I'm
a
sorry
policy
you had to go
violation.
through that.
Thank you. There's a difference between a policy violation and there's a difference between alleged act, an investigation, an indictment, and an arraignment. Very, very different things. To put them in the same pail or bucket, I don't know how you do that. It keeps coming up that I did nothing. I answered phone calls from the survivor. I talked to her. I encouraged her to report it. I encouraged her to continue to seek counseling. I didn't do nothing. I continued to try and get her to a place where an allegation becomes an investigation and becomes a potential outcome with accountability. That's what I did over time. In 2017, I did not have a cooperating victim. And you as a lawyer know that without a cooperating victim, nothing's going anywhere in the criminal justice system. That's what Ms. Keeley was going to talk about tonight, was that there's no ADA in the world that's going to bring that case forward, okay? We're hung up on promotions too. Yeah, he got promoted, but he, like Mr. Fogarty said, he was second in charge as lieutenant, he was second in charge as deputy chief. It doesn't,
So what concerns me is the position of power and allowing a person to gain more and more power. That's really what I'm struggling with here. And I do want to thank you for your years of service, and I know that you were well-intentioned. But I'm looking at this from the position of how does the police department work without appropriate reporting? And that's the perspective I'm looking at this from. I'm all set, thank you.
Okay. Do you want to say anything?
No, I
so
appreciate
I'm sorry, everybody has asked their questions? Mm-hmm. Okay, go ahead, Nick, I'm sorry.
No, thank you. I think I made my point on the false equivalent suggestion and sort of the distinction that we're drawing in these two buckets. Thank you.
Okay. Chief?
No, I have nothing to add.
We really appreciate the time and effort that you're putting into this decision. We've heard each of you, and we understand that this is difficult. The recommendation that's been made tonight, which is not the original recommendation that was for the first Loudermill hearing that was issued back in September, up to and including termination, was the language used back then. The recommendation for termination is not supported by just cause, and we do not think it is a fair result or a fair outcome in this situation. And we ask you to consider everything that we've discussed and gone over together as a group in making your decision. Thank you.
Sergeant Brennan? Do you want to say anything?
I want to apologize to the board for having you donate a lot of your time and to better my life as an employee and as a resident. And I'm sorry that you have to donate more time because of something I'm involved in. This is a difficult situation. I'm not going to lie. You all have said it. And I just want you to understand that I did what I did to try and protect the victim and to get her to a place where she would voluntarily report. So thank you for your time.
This is our opportunity to deliberate as a board.
Would you like us to make a motion first?
I don't think we have to make a motion first, or we can just deliberate, but,
We have Brian here to answer that for us.
say it again?
We have Brian here to answer that for us. Do we need a motion?
You can deliberate, you can make a motion and deliberate on the motion. It's really up to you. I think maybe it might be easier to make a motion and frame it that way, but you don't have to do it that way.
So,
So I guess I would make a motion to accept the chief's recommendation to terminate Sergeant Brennan's employment.
Second.
And then we could discuss, right?
yep. So it's been moved and seconded, moved by Amy, seconded by Mary Jo. I hear you. So, I do not personally support that motion. I think that there is discipline that we can consider that is, to use my word when I started, restorative. Sergeant Brennan has had a 23-year career in Hopkinton without any disciplinary infractions. I know personally that it is a very tenuous and difficult situation to work with a person who has experienced sexual violence. It is not straightforward. I respect that he centered on the victim, on the survivor. I struggle with the fact that he didn't find a way to report somehow. But I also know that the Hopkinton Police Department is better with Sergeant Brennan, and I know that he would be welcome. Please, okay. I have professional experience as a social worker. We've listened to both sides. I have professional experience with trauma-informed care. A lot of that got a little bit muddied. It is so hard to know what to do when you are confronted with somebody who is in that kind of a vulnerable situation. I have every confidence that Sergeant Brennan did what he thought was best, and that's all we can do sometimes. I also understand that he needs to earn his way back if he's able to come back. I understand the complexities of this situation. I think we have to think about the best interests of the adult survivor, the best interests of the Hopkins Police Department, the town. Sergeant Brennan, certainly his experience and his dedication. Have to consider the chief's position really thoughtfully. I hope that we can come to a decision that provides a path back, because I think that is the thing that will be most healing and constructive for the community. That's my position.
So, as I had mentioned earlier, I'm viewing this from the position of an elected official who oversees the police department, and how is the police department supposed to operate without reporting? And I know that Sergeant Brennan is an excellent police officer, and I know that our community is better with him. But in this situation, I think by failing to report, he usurped the chief's authority in what in promotion, in decision-making, and I have a hard time with this one, because I think that to have a properly functioning police department, we do need a strict reporting requirement. And in a situation like this, there's got to be a way to say, hey, chief, here's what I'm up against. You can't say anything. She will recant. But you can't let that guy keep building in his career. You can't give him more power. And that's what I'm hung up on. And what the appropriate discipline is I do think that, termination is very difficult, but and I think as a board member, if there was something less through negotiations, I think we'd be willing to accept it and negotiated. A negotiated deal.
So, also not to be overly practical, it has to be sustainable.
Mutually agreed upon too. So.
Anybody else?
Yeah, I can go ahead. But I really appreciated hearing from everyone tonight, Chief Bennett and Sergeant Brennan and their council, and all the members of the public who attended tonight. And as much as I really do like Tim as a person, I've always had good experiences with him myself and on the Growth Study Committee. And I know he's done many good things in town over the years with Scouts and has lots of loyal friends and supporters. Good people sometimes make serious errors in judgment, and I just cannot get past him knowing in 2017 that a member of our police force was accused of sexually assaulting a minor and he didn't report it. And this allowed the alleged assaulter to continue to work in our town and continue to advance, and for him to continue to be in a position of power put our community members in danger, and this behavior erodes the public trust. And as we know, most rape survivors are reluctant to report or press charges due to years and years of history of them not being believed. But the police officer duty is clear. There are a variety of different ways it could have been reported without re-traumatizing the survivor and still preventing potential harm to other community members. Allegations could have been reported anonymously to the Chief Lee or the state police or the DA. We have these rules and regulations in place to protect the people and to maintain the integrity of our police department. Police officers enforce our laws, and they need to be held to a very high standard. So we need to set an example for our younger officers coming up in the ranks that they should not fear reporting a fellow officer for wrongdoing, and ensure that our residents trust the police that are here to protect and serve the community. And I really liked him personally, but I think this was too big of a mistake.
I'll add a few. So Tim, I know you as a good person, and
Mike.
hello.
I don't think you're on.
Might not be working.
You want to switch with Amy?
Yeah, here,
I think it's working. No,
no,
sorry.
it's all right.
Tim, I know you personally and your family, and certainly appreciate all you and your family do for our community. You're a good citizen. You have served our town 22 years with great reputation. There are many people here. You are loved, and certainly it's very hard where you are. And I'm sorry you and your family have to go through this. I can't imagine what you all are going through. And I also know that from the Growth Study Committee, you're a very thoughtful citizen, resident of the town. But we are here as a elected member to do what's right for the town. And this is extremely difficult situation for us, and for all the reasons that we are mentioning. But we need to look at, in my view, from the broader picture, as our police department functioning with the right discipline, with the right ethics and right common sense in many ways. And of course the policies and procedures. And the lack of judgment that's reflected here, the lapse in decision making because of personal or individual unique analysis that you provided is not substantiated enough to compromise with the department's standards and discipline, in my view. And our decision is not only for today and for what happened. That is definitely is what's driving towards this very difficult decision. But how we are going to operate for tomorrow, how we are going to tell a new recruit or a new member of the police force how you have to respond. And this is going to be a big precedence. And everyone is going to look at it from a town, from police department, from state, and wherever this situation arises. And it's very difficult to comprehend that some individual complex relationship and others will basically stop from reporting a potential crime or potential extremely unethical behavior in the police department. And that would result in so many ways harmful to the town, to the society, the alleged perpetrator promoting, getting into more power, and communicating, connecting with other minor girls and others. And as a parent, that is scary. How do we and where do we go to trust the police department if everyone starts thinking that way? I'm different. I have a unique situation, and I can use specific individual judgment. And the voices of the
Take a minute, just take a minute.
Sorry about that. The voices of the vulnerables can be lost. So I don't think we can, in my view, have any other choice but to discipline. And I don't also see how Sergeant Brennan can return in full capacity with full trust of the department, of the town and be an example for going forward with what we expect from our police department and the police. But I do recognize his contribution and his personal character, and I would also add an amendment and request my fellow members to consider for reducing the financial impact of this by considering up to a year of payout or severance, and should everyone agrees to the termination and this, and also to uphold his earned benefits to reduce the financial impact, and we all can move forward, so can he, and it's time to heal, time for all of us to move forward to keep our town as harmonious and as good a place to live as we are. Thank you, and sorry about the emotional burst.
Like I said, this is the hardest thing I've done in the whole time I've been on the select board or in any office in town, and I've held a great number of them. And I love the Brennan family. I love Tim. And there are ways in which we could probably settle this. And I'm not sure that in public like this is the right way. I agree with Shahidul about the severance pay, but I also think that if Tim were to retire, he would retire with all his benefits and everything that he has, and then he can go to a college and join another police department again, and he would be fine, gone. This wouldn't be here. We wouldn't be here, and I just think that that's a good suggestion. It's just a suggestion. But that's right. If he's fired, he can't do that. So this is it's up to Tim. This hearing was up to Tim. It wasn't
Please, audience, we asked you several times, please. Can we just have our deliberative process here?
It's just a suggestion. I want to look out for him. I want to look out for his family. I want him to leave the best way he can. That's all.
Take seriously, it sounds hokey, but a deep breath. Look, nobody pre-thought anything. We're all struggling. I read what I wrote. You just liked it better. I read what I wrote as well. I read what I wrote. Everybody.
She was reading it.
So was I.
This is ridiculous.
All right. Let's take a 5-minute break.
We only got the information Friday like everyone else, and we read it over the weekend, and then there was no meeting on Tuesday, and I had a couple of days to continue to read. I didn't read anything tonight. I didn't bring anything with me to read.
No, she's talking about me.
We're taking a 5-minute break. We're taking a 5-minute break.
Okay, we're in recess again for 5 minutes.
We're gonna,
Yeah, I know.
we're gonna, oh, we're not live.
Hundreds of thousands of dollars.
It's not.
We're gonna reconvene. Yes.
Yes.
Aye.
This is really gonna make the big people.
No one ever be a cop. Want to be a cop?
Hey, Dana, I'm asking politely if we can take it down. I actually called the session back. We're waiting.
I just want to make sure that you know that Tim did not know anything until she was an adult. Not when she was 14 years old. She came to him as a grown
Ma'am.
adult. Sorry.
It's all right.
5 years later.
Listen, I understand
matter.
everybody's emotions
He
are
never
high.
told anybody that we had. I do know the timeline. I've been reading it all
Mary
week.
Jo,
Yeah, okay. I got
just for
it.
yourself.
Think creatively. Porter got to keep his pension. Tim should keep his. Tim's a far better man than he is.
Timmy gets fired because you guys promote Jay Porter? Really?
That's Timmy's fault.
You're blaming Timmy?
How does that make sense?
Yeah.
If we had known he was a possible pedophile, I wouldn't have.
I don't think I could have said it any clearer.
Nothing you can say.
We're still live, you guys. We're live.
Were it not for Tim, you wouldn't have a case against Porter.
Very true.
You can talk amongst yourselves, but I'm just asking people to keep their emotions in check. I know.
Go on with the mask.
Just the same thing.
It's not a termination offense. At the end of the day.
It's just a bigger
They'll figure it out. None of them will be here, but they'll figure it out.
She's very good friends with him. So her mind is very good.
drink.
I could too if you didn't. Are you going out this bubbler?
No,
No?
something
Oh, you
stronger
don't-
than that.
You two, we're going out after this. Let's go.
Oh,
I
man.
might even have a Manhattan to show you do. I haven't had one of those in years.
We can't go without them. Where's
Keeping Cyrus up so I can see him before he goes.
Oh, well,
Maybe
we're
we
not gonna,
should, we should,
Yeah, someone called.
Huh?
we're not gonna be late there, but, you know, it's funny.
know of, I don't know, I think people are talking, I don't know, I think maybe we should, hey Jim, we should just continue the break, 'cause, sorry. for the, we're just waiting for the attorneys. Okay.
At this point, I'd ask to be heard.
Sure.
We've had the opportunity to address the issues before the board, and we've heard your deliberations. We've also heard some concern from each of the members about exactly how to bring this to a conclusion. I would propose that the board could choose to table the current motion, suspend the hearing, and allow for further discussions at a later date.
Madam Chair?
Yes.
Madam Chair, I move to table the motion, continue this hearing, and allow the parties to work out a mutually amicable solution.
I second that.
Just as a quick point of order, we
We
need
have-
to table the pending motion first, and then we could move to continue it. It's sort of two motions, but it's the same deal.
Okay.
Okay, so I'll entertain a motion to table the initial motion that was made before the break to consider a different motion.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, could you repeat the motion, the request, or you made a
So,
motion?
yeah, so my motion is to continue the hearing, to allow the parties an opportunity to negotiate a mutually acceptable agreement.
And you seconded it? All right, so it's been moved and seconded. So I would request a date certain for the conclusion of this. Is that, can we aim for a date?
So this is one of those great times where I'm not an attorney. I don't have to answer that, but and I can play the judge role and ask the parties, how long do you think it would take to, how long would you need?
I think we need it at least to the end of the month.
End of January? Or 30 days from today?
Why don't we do 30 days for today?
I'll,
And is that acceptable? 30 days from today?
Yeah.
That's the date certain?
Yes, absolutely.
Okay.
Can I make a statement too?
No.
What day is that?
What day is the 30 days from today?
to the audience,
May I be
we're
heard?
not getting paid for this.
Madam Chair, it's a Monday.
It's a Monday?
I just want to make sure it's not a holiday, though, is it?
It is a holiday. It's President's Day and school vacation.
So- We've got plenty of time.
So let's,
what are
that's
we-
the
what-
date certain that it has to be done by, but we're gonna convene and conclude before the 19th.
That's the board's,
What's 19th? Let's dial it back. 18, 17, 16, February 16th.
is that a Friday?
It's a Friday.
Another Friday?
16th of February. That's the date certain that they have to be done.
Oh. no,
Okay,
I
is that
cannot-
right?
Okay.
I cannot
Yeah,
do
that's a
that.
Friday.
Well, we don't have to meet necessarily, right? It's when you have made your,
Or not, right? But
what? What are we actually agreeing to here? I don't,
We're going to postpone some.
But yeah, it's,
all
I
right.
would just say suspend the hearing.
Okay. I like that. All right, so we're gonna vote to suspend this so that they can meet and deliberate for up to 30 days. We will stay in control of when we set the meeting, but they have 30 days to work this out. Does that work?
So we don't need to set a date.
That's
right
fine.
now?
Don't need to set it, it's 30 days.
And that was my comment about or not, we
Yeah,
wouldn't need it.
yeah,
That isn't a
okay.
hard date, that
Okay.
we have to set it today as a date. If there is a mutually acceptable resolution, there'd be no reason.
We wouldn't wait 30 days. If we could do it in 10, we'd do it in 10. Okay. All right, does everybody understand the motion?
And then if we needed to post another meeting, we would post it at
If
that
we,
time.
yes, if we need to post another
yeah, if we
meeting,
don't
we will
get-
post it. Exactly.
So essentially, we are tabling, essentially we are tabling.
Oh, yeah.
sorry
You
about
got a mic that's not working.
Essentially, we are tabling this today's session and giving time for discussion, be there a negotiation or not, and reconvene for making a decision in 30 days. Is that right?
Yeah, they are gonna have an the parties, both parties, the town and Sergeant Brennan, his attorney, will have an opportunity to negotiate.
Thank you.
Am I right on that? Okay.
So I move the motion to,
It's been
Oh, it's
moved,
already
it's
there.
been seconded, yep, and it's explained. All those in favor say aye.
Aye.
Any opposed? Any abstentions? Entertain a motion to adjourn.
I move the motion to adjourn today's session.
Second.
Second.
All those in favor?
Aye.
Folks, I want to thank all my friends for coming and my family, and I really do, from the bottom of my heart. I appreciate. Thank you. Thank you very much. What I wanted to say was I appreciate everyone's support, but please, these folks that are in front of us are volunteers. They don't get paid for this, and please treat them with respect as they leave. And thank you for coming.